Welcome to the Wealth Transfer Podcast. Today's guest is David Johnson. He's a fiduciary litigator and partner at Winstead PC in Fort Worth, Texas. He's known for representing trustees, executors, beneficiaries. He's seen some of the most complex trust and estate disputes, and I just really enjoyed hearing his deep legal expertise and practical insight, and also telling us what goes wrong behind closed doors, from contested wills to fiduciary breaches and family conflicts. In this episode, he shares a bunch of real-life stories, some legal principles, and some ideas about what modern estate litigation looks like. He's given us some great ideas for families and advisors so that they don't end up in court. Whether you're managing your own estate or you're guiding clients through theirs, this conversation is packed with wisdom from the trenches. Let's get started. So David, let me ask you first, tell us about your background. How did you get into law? What is your legal background? Tell us more about yourself.
Well, so I come from a family of lawyers. My father was a judge, a state district judge in Waco, and was appointed by Governor Conley in 1968, served on the district court bench for 25 years. And so my brother became a lawyer. He was older than me. I kind of dabbled with an accounting degree, and I then clerked at an accounting firm and realized that it's not what I wanted to do. And I keep telling my daughter, it's important to have clerkships and internships, not only to know what you want to do, but to know what you don't want to do, because that drove me straight from accounting into law school. And I thought I was going to do estate planning. I was going to do estate tax with my accounting degree, law degree. But I went to Baylor Law School. It's known for litigators. It's known for litigation. And so it kind of turned me to the dark side, and ended up coming kind of full circle and doing trust and estate litigation. But that's kind of my story. And so I ended up lawyer. My wife was a prosecutor, and she's now a municipal judge. My brother's a judge on the Court of Appeals in Waco. Two nephews were lawyers, and my daughter is thinking about law school. So, it's a family profession.
Family industry. That's great. Now, when you say that you're in trust and estate litigation, what specifically are the types of cases you see, or the types of situations that you're dealing with on a day-to-day basis? So
I've heard someone else say this. What I do is kind of family law with the dead body. And not always. Sometimes the matriarch, patriarch is still alive, but usually they probably passed, and their kids are fighting over either their estate or a trust, or there's a family business that is owned by with the family office, maybe owned by trust, maybe owned in some other platform. And so we're having disputes about that. And so, I represent a lot of corporate fiduciaries, trust departments, and banks and other financial institutions. Represent a lot of individuals who are fighting over it, for both as a trustee or as a beneficiary or executor. And so those are kind of the disputes I handle.
And when you say, obviously, litigators, we tend to think they get to the courtroom. Are you doing a lot of this work outside of the courtroom, settling these things, or are you actually having to fight them in court as well?
Both. That's a great question. A decent amount of my work, and it really isn't necessarily all that contentious. Sometimes we just have to go to court to get a trust modified, or to get some other, to get an order to allow us to do something. And everybody kind of agrees to it. It's just a process you have to go through. Or the trustee says, I'll make these distributions for you, but I want you to do a release agreement, so nobody's going to sue me over it. And so, so we'll help facilitate those by drafting agreements, going to court, getting orders done. And so, that is a certain portion of my practice, is kind of helping facilitate getting things accomplished in a trust and an estate, where it's not necessarily contentious. I would say probably most of my time is spent on the contentious cases, doing depositions in court, having hearings, trials, and whatnot.
That's awesome. Well, and one of the things that we work in real estate, and oftentimes we deal with estates or family properties, after someone's passed as well. And I always say the fastest way to make siblings never talk to each other again is to go through splitting up mom and dad's assets that are hard to split, and figuring out how to pass those. It's just so sad to see siblings fight. I'm curious what some of the interesting situations or stories you've seen around how families deal with both the grief of death, but then also just dealing with the estate.
I see the sad cases, right? I'm very dysfunctional families that probably have had issues for decades and decades and decades. And the parents don't do a particularly good job of setting them up for peace after they pass. And so, almost all my cases deal with dysfunctional families and siblings or cousins or whatnot fighting over real estate, oil and gas assets, closely held businesses, what have you. I had a case and it was a family and mother and father. Father died in 1972. Mother was 98 years old, was still alive in 2020, 2021. And they had about 120,000 acres in West Texas. There was 3 different ranches in 3 different counties. And they had 3 children, two daughters and a son. Being an old fashioned family, the son was set up to was the trustee of everything, was the one in control of everything. And so I represented one of the daughters who was 76 years old and had never had a distribution. The ranch land property in her trust was worth, over $30 million. And she'd never gotten a penny from it her entire life. And she's like, I'm 76 years old. I'd like to, have some benefit from this. And so we ended up filing a lawsuit and litigating it for a year. And then this is over COVID, and we had 5 different Zoom mediations. It was very difficult because, it wasn't just like, here, you get this money out of this account or whatever. You're dealing with all this, this property has these hickeys, we've got this boundary dispute, and we've got this issue over here, and we're having to kind of resolve all that. And so we eventually got it finished and accomplished and partitioned out. And so my client had complete control over her, 1/3 of the property, and was able to, go on with her life. And so that was a good result, but it was a painful process. And that is something that you see very commonly is, I would say oftentimes it's the oldest son who's in the position of control over the family property, whether it be a trustee position, executor position, maybe they are the president, CEO of the family company business. And, they don't want to tell anybody anything. They're very secretive, and that creates distrust. And then they're the one in control. Don't question me. I'm going to do what I want to do. And that's the way it was set up. And that just obviously creates a lot of distrust and, at the end, hate.
Well, that's a great point. And you really nuanced it well. Is there a way that families, like especially on this side of death, could set up trusts or set up their estate? Do they need to hire a corporate trustee? Do they need to put some language in their documents? What would you suggest in that specific situation?
So, yeah, there's multiple different ways to handle it. And so, like you said before, we're about to have this baby boomer generation transfer of wealth. There are $84 trillion estimated to be transferred over the next 20 years to Generation X or to the millennials or to whoever. And that's a lot of assets being transferred and a lot of families. And you're going to have a lot of disputes over that. And there's some things you need to do, people need to think about with regard to planning. I see it. I've heard people say this. I don't care. Once I die, I'm dead. I don't care. Right. I'm not going to deal with it right now. They might even have a will. They may be worth $100 million. Don't even have a will because I just don't. I have a hard time understanding that. To me, I would think if you love your family, you don't want them to fight when you're gone. But for whatever reason, there are some like that. And there's very little you can do to get them to get off base and do some planning. Most people, I think, would tell you that they don't want their kids to fight. And so it's a matter of doing appropriate planning, having a good planner who understands tax law, who understands dispute resolution and how these things are going to happen and play out in the future. And so I would obviously investigate, good due diligence, interview multiple different lawyers to understand, if they had similar experiences, similar estates, and what their process is. Secondly, I would say this, whether I'm representing a trustee or an executor, certainly as someone who's setting up their estate, and it's communicate. I don't think there is enough communication, and that causes distrust, that causes anxiety, that causes these fights, these very expensive fights that occur. So if mom and dad would just sit down with their kids, have a family meeting and tell them what their plans are and why they're doing it, I think that would really alleviate a lot of the fights. Not all of them, but a lot of them. And there are any number of things you can do to help avoid family fights. And I don't know how much you want to get into it right now, or if you have specific issues you want to talk about, but I have kind of a laundry list of things that I would recommend.
Let's talk to the laundry list. What are some of the things you immediately recommend, and in a second, we could even unpack what are some of the common problems you see that need to be addressed? Either way.
What you often see are people who haven't been communicated to. They don't understand why mom and dad did X, Y, and Z. They're concerned that mom or dad may be losing some capacity. They're not as sharp as they used to be. They're concerned that one side of the family has influenced them to benefit that son, to benefit that daughter, put themselves in a position of control, give themselves extra assets. And so with this kind of distrust, you can see why that leads to fights over whether the document that they've signed is valid or not. So some things you can do to avoid that. One is, and I always say this, if your elderly parent presents well, right, you should really consider doing a video or an audio recording, having them discuss their estate plan, why they're doing what they're doing, showing that they have capacity. And so videos like that are really very hard to get around if you're trying to challenge it, if the person presents well. Problem is sometimes people don't present well, but yet they have capacity. Maybe they have Parkinson's and they can think just fine, but their facial effects or their tics are having issues that make them look infirm. And so that may not always be a good strategy depending upon the case. I would say one thing is you can go and get a doctor to do an evaluation, maybe a certification that they're mentally competent. You could do that I would recommend doing it the day of. So if I know they're going to go in and sign these documents in the afternoon, that morning I go to the doctor, get them to do a test, and do a fairly thorough examination. Make them sure they last an hour, hour and a half, not just some simple, 5-minute visit with a doctor. And that can really ward off, at least with regard to competence. Another thing you can do is have multiple documents signed over a period of time. And the issue with that is that if you have a son or a daughter that's going to challenge a will or challenge a trust, and let's say they're successful and they get that kicked out, if you've done it 6 times over the past year, they have to go back and challenge each one of them and prove that on that day they didn't have competence, or on that day they were unduly influenced. And so that's a pretty standard strategy. If you have businesses, real estate, I think it's important to have buy-sell agreements or provisions between the family, because I think you mentioned earlier, and that's something you commonly see where you've got real estate, you've got a business, but we don't know how, we each have a third of it. How, I don't really want to be involved in the business. Well, actually the problem typically is someone who just wants to get money from the business and not do anything in the business. And the people that run the business feel like that's not fair. So I'm going to pay myself a salary. And then you have this dispute of, well, is that salary reasonable because this other person is not getting it, they get a distribution. And so really what you need is a business divorce in that circumstance, and to get the family separated so that they've got their assets and they can control them. And the other person is not begrudging the fact that, I'm doing all the work in the business, but I'm not getting all the benefit. And so buy-sell agreements are a fantastic way to help resolve that with regard to those assets. You can have no contest or interim clauses in documents. What that means is if I challenge the document and say that the person was incompetent or unduly influenced, and I lose, I may be cut out. So I no longer get the benefits of it. And so it really can dissuade people from filing lawsuits if it's a close call, because they're concerned that, if I lose, I may not get my third. And the clauses can be drafted broadly or narrowly to determine kind of how broad you're going to have this detriment of this risk, right? You're trying to avoid risk. And so that good drafter can help draft those. You can have arbitration clauses in trust and estate documents. I don't know that people understand that. And to be honest, I think historically most lawyers would say, I don't know that would be enforceable. Texas Supreme Court came out about 10 years ago and held that arbitration clauses and trust documents on wills are enforceable. And so, that means it's taking out of the court system sometimes the big sword in these fights is, and I'm going to sue you for breach of fiduciary duty. I'm going to sue you for unduly influencing mom and dad. And we're going to have all these horrible things paraded in front of the public. And that's a big leverage piece. If you have an arbitration clause in there, that makes everything private. And so they have to resort to the AAA or some other forum, and everything's private. And it takes that kind of concern out of it for the family. There are a lot of families that are very private, like they're very kind of maybe historically public families. And they don't want, even after I'm dead, I don't want my grandkids putting my dirty laundry out in the public. And so an arbitration clause is a great way to get that accomplished. There are detriments to arbitration clauses. And so it's something that should not be just put into every document. An estate planner should sit down with their clients and explain what it is, explain the process, explain the good things of it, and explain the bad things about it. And then let the person who is signing the document make the decision whether it should be there or not. There are some other things you can do with regard to actual drafting of the will or the trust that can, sometimes you see kind of people who usually are upset, not always, oftentimes in a trust situation, it's a beneficiary who, I've been a little bit of the black sheep of the family. They don't feel included in the decision making. They're not in control, probably not in control, maybe because they've had drug issues, maybe because they've never had a job in their entire life, maybe because they've been divorced 3 or 4 times, or, there's any number of things. And those folks get upset. They're typically irrational. You can have language in trusts or wills that I call bad boy provisions that say, if you do drugs, you're cut out. If you have a crime, you're cut out. Or the trustee doesn't have to make distributions to you. You can make distributions for your care and benefit, but it doesn't go directly to you. And so there's language in a trust or a will that can help dissuade those people from being kind of bad people or to challenging the trustee all the time. I would say to be careful with that kind of language because typically trustees don't like it. If you're a corporate fiduciary or an individual fiduciary, that puts a lot of pressure on you to have to be a policeman and make sure that, son or daughter isn't doing drugs or isn't committing crimes. And if they are, then I have to make a decision. And trustees hate making decisions like that. Do I cut them out? Do I not make the distributions to them? So I've had clients who say, I'll take this position as a trustee, but we're going to modify this trust and take those provisions out. So that is a risk, but I have seen those being very effective in some cases. I would also say the selection of the fiduciary, whoever the executor or trustee is, can be a huge, huge issue. And they put a lot of thought into, am I going to put firstborn son as the trustee of this trust? I mean, you're setting up your family for a fight, so people should consider, and I represent a lot of corporate fiduciaries. There are some that are very against corporate fiduciaries these days for some reason. I think a corporate fiduciary can be a great solution to a family who's very dysfunctional, whether that be as a sole trustee or sole executor or as a co-trustee or co-executor. There are also people who used to work in a professional fiduciaries, and those can also be a good solution. You have to make sure you vet them, understand who they are and their experience and what their views are in life. But someone who's outside the family, who can be more objective and maybe can communicate well with the family and make them understand why they're doing what they're doing and whatnot. What I have seen, and I would be very careful. And I was just talking to a partner about this. I think Jimmy Buffett has a famous kind of estate issue going on right now. And I think this is a good example of it. If you have the matriarch, a patriarch, has had a long-time lawyer or a long-time accountant or a long-time CFO, whatever it is, maybe you have a family office and you've got people working in that office. If you make them a co-trustee or a co-executor or just a sole executor or sole trustee, I have found that to be problematic. And the reason is the dynamics of it. They've been with the family so long, they're almost kind of part of the family. And so people have grudges against them already. And those people, to be honest, sometimes kind of feel like they've got an extra right to control this stuff. And it's my decision and you have to live with it. And so...
Well, and they have their favorites, right? So they've already kind of prejudged everybody. Everybody's, specific positions in the family have already been decided, and there's no objective. Everyone's equal, or everyone's treated, according to how they're named in the document.
100%. I mean, that's exactly.
Yeah.
And so I had a big case out in Midland, and we went all the way. We picked a jury, we started a trial, and we settled it. But it was co-trustees. It was surviving spouse, and they've been married for like 50 years, right? A surviving spouse was the co-trustee with a lawyer / general counsel of their family business who'd been with them for 30 years. And now they're just fighting tooth and nail, and they can't agree on anything. Lawyers like, well, this is the way your husband wanted it done. And wife was like, no, that's not the way my husband would have wanted it done. And so, I just saw that as a perfect example of someone who had been in the family a long time, working for the family, that now has this taste of power, and they're going to exert it. And it was kind of a really ugly situation. So I would say I would counsel people to really think hard before they put someone like that in a position of authority to make sure they have the right personality for it.
That's a great thought. Yeah. I was also curious, there's a lot of different problems that come up. We talked about sibling rivalries, talking about some of these different trust and document issues, which are awesome. But also one of the common things you probably see and I see as well is elder abuse. So tell me more about what you're seeing as far as people getting older and then how they're treated at the end of their life by their heirs.
I see it a lot. And so I have a blog, fiduciarylitigator.com. I post regularly. I do quarterly webinars. So I'm kind of out there on the internet. And so I get a lot of calls every week and emails every week from all kinds of folks, mostly from Texas, but also from other jurisdictions. And I hear these horrible, sad stories. Unfortunately, I can't help everyone. Everyone's not quite right fit for me and my law firm as a client. You hear of my aunt has her estate plan, and then she fell and she puts into a hospital. This other part of the family comes in who she didn't like historically, and they change everything. They change their, all their accounts, put them as beneficiaries on the accounts. They create a new will, do all this stuff. This person has medical records saying that they are, delusional, doesn't know where they are. They think Harry Truman's still the president, things like that. And it's just insane. And it's really sad when you see that, but it's very common, and it happens in very wealthy families, and it happens in very, poor families. It just happens all the time. And you have both people within the family who will take advantage of people who have mental competence issues or diminished capacity. Even if they have some capacity, they maybe have enough capacity to sign a will, but it's diminished. It's not what they were 10 years ago. It's not what they were 20 years ago. You also have outside influences that come in. Be very careful with the nurses and the people the home care people that come in and help sit with these elderly people, because, they'll start writing checks for them. They'll start, all of a sudden they become a power of attorney for them. All of a sudden they're changing their accounts. And it could be neighbors. It could be handyman. I had a case, and it wasn't that big of a case. It was over $1 million, less than 10 million. And it was this woman that had nieces and nephews that didn't live in town, and they had a handyman, and the handyman's family kind of adopted her and started taking care of her. She was an alcoholic, brought her, her vodka, and, changed all of her stuff and made his family all of a sudden the beneficiaries of her estate, taking out the stuff that she had planned for her entire lifetime, going to her other family. So it can be anyone. It can be lawyers, unfortunately. It can be financial advisors. It can be anyone that can come in and abuse elderly people or not necessarily elderly, but people who have mental capacity issues. And so we had more and more laws being created to criminalize that conduct. The problem is enforcement. There's not the funding at the local government level to have people who are dedicated solely to investigating and prosecuting these kinds of elderly abuse crimes. And you see it's just exploded over the past 15 years. Elderly abuse has been around for as long as man has been around, probably, right? But the amount of wealth that's been generated, and you see the government, creating pressure on banks and financial advisors, broker dealers to investigate and report these instances. And I could go into more of that. But, it's a big issue, and I just wish there was more regulation. And what I see, and I see a lot of other lawyers like me will say, look, we've reported these things to adult protective services if they're still alive, or reported it to the police and tried to get it to the DA's office if they're passed away. And what happens? Nothing happens. And so, they'll tell you, well, it's a civil matter. You got a lawsuit over it. You should go handle it in the courts and get your money or whatever. And that's not the way it should be. And it's not what the legislature intended. And I'm not saying that, there's some great police officers out there. There's some great prosecutors out there that it is prosecuted, but not as much as it should be.
You said you feel like there should be more regulation. What are the developments you're already seeing around elder law, specifically around abuse or even other issues arising from these sorts of things? Are you seeing any developments in the law?
So, and I don't know if there needs to be more regulation. I think there needs to be more enforcement, I would say. And for example, probably 10 years ago, there was some new provisions done in the Texas Finance Code that requires banks to report these instances when they see them. Very similar statutory language for broker-dealers, registered investment advisors. Texas Human Resources Code has had provisions in it for decades about reporting financial exploitation. And you just don't see, people come in and get bank accounts changed all the time. The elderly person isn't there. The bank doesn't follow up and say, hey, do you want, and you call the client and say, is this what you want done? You don't see that being done. You don't see any investigation being done. You don't see them reporting it. They've got statutes saying you're supposed to do it. It's not really much of a slap on the wrist if they don't do it. There's some issues with that I'd like to see changed. I represent banks, so they'll probably get mad at me by saying that. But I think that if there was more reporting of it done, then some of this could be ameliorated before the person passes away.
Yeah, that's perfect. I want to switch gears and talk a little bit more about trusts, because obviously you've written a lot of both blog posts and white papers on trusts and even the wind up of them or the completion of them. So my first very simple question, because I want to go high level, is how long do trusts last? If you start a trust or if you make a trust, what's the lifetime of the amount of time that a trust lasts for?
That's an interesting question. And so the answer to that is it depends what jurisdiction you're in. There are some jurisdictions where there is no rule against perpetuities is what we call it. It's a legal term that says that we're not going to have things locked up, whether it be real estate or trust over property, for indefinite periods of time. And it's kind of you don't want the dead hand of an ancient ancestor controlling these assets hundreds of years later. And so, historically, your rule against perpetuities would be can only last 20 years after a life in being at the time of it, meaning if my great grandkid is alive when I sign this document and they're a beneficiary, then after they die, the trust can last 20 more years, essentially. And so, you're probably going to look at a lot of trusts lasting maybe 80 years, 100 years, something like that. There are other jurisdictions that don't have a rule against perpetuities, so it can last forever. So that is if you want something to last forever, you may want to think about, where do I want to create my trust? What jurisdiction do I want to be in? I think because of that issue, Texas has recently, last 5 years or so, has changed the rule against perpetuities to make it 300 years. But 100 years for real estate, 300 years for other trusts. And so it's greatly expanded, and there are ways to maybe potentially go back and fix older trusts to have the new rule against perpetuities applied to them. Also point out that it's always been the case that for charitable trusts, that the rule against perpetuities doesn't exist. So a charitable trust that's set up can last for forever. But that is something that if I'm doing the planning and if I'm putting these assets in here, then I want to think about, how long do I want this trust to last? How do I want to draft that? There are some folks that are, high net worth that really want to have a dynasty trust, something that does last for just multiple generations. And so that's great if you want to do that. I think there needs to be a lot of thought put into having provisions of that trust that encourage beneficiaries to be productive. And I say that because you have a huge trust that's worth $1 billion, right? And I've got clients that have trusts worth, $700 million, $1 billion. You see, by the third generation, you'll have 20 beneficiaries and literally one of them has a job. probably not what you want your family to be like in 50 years. So you can have things in your trust that has the trustee gives the power to the trustee to make sure that people have jobs, they get education, that the distributions aren't meant for lavish lifestyles. It's meant just to be supplement. And so if you want to have a lavish lifestyle, you better go get your own job to help supplement it. And so that would be maybe a suggestion for those types of trusts.
So in one of those situations, because did Texas has always had a law against perpetuities, or did it at one point have an unlimited?
Texas has always had the rule against perpetuities. That comes from the English law. It was, from England that got over here to the U.S., part of the common law. And so Texas has always had that. I would say that, I think there was a push to change it in Texas because Texas was losing some trust business to other jurisdictions that don't have rule against perpetuities. And so there was a push to make the legislature change that, make it a more liberal rule against perpetuities, so people want to keep their trust business in Texas.
And when it's now that it's potentially 300 years, does that retroactively apply to previously created trusts, or is it only for new trusts created in the future?
So technically, it only applies to trusts that are created after the date of the inception of that Tory provision. And I don't remember the exact date, 4 or 5 years ago. But, and I have a blog post on this, but potentially there's an argument that you can go back and reform older trusts and potentially have them applied. There's an argument you can do that. There's not any case law or statutes really discussing that, but there are potentially some creative ways to do that. You could potentially decant from an old trust into a new trust. There's kind of multiple different types of planning or litigation strategies to potentially have an old trust fall under the new rule against perpetuities.
Now, let's say, obviously some people might want a dynasty trust, and you've got this one big trust and you've got a bunch of beneficiaries. So you've got probably a team of corporate trustees or a corporate trustee with a team of people who are managing this large trust. Is there any strategy to having where various beneficiaries get their own trust, or that it's separate versus one big one?
Yes. And I would say probably that's not unusual. I would say probably that's typical, that at certain generational levels, you split the trust apart. I've got one right now that is not the case. It's a large pot trust, and it's a big trust, and with different beneficiaries, different levels, the kids, then the grandkids, now great grandkids. And that causes all kinds of problems and disputes. So I think it's a good idea to split it up, at least along family lines. So, after mom or dad dies, then you split it between the kids. And so, this person and their kids get a trust. This person and this folks get a trust. You have the same trustees of all the trusts, potentially. You could potentially have maybe a corporate or an independent individual that's a co-trustee with the first level of each trust. So there's different ways you can do it to strategize that. But I think that does help eliminate some of the disputes between the families about you're getting more than I am.
What other considerations should people, when they're first getting trust, maybe they've not put anything in trust and they're saying, I need to decide if I'm going to put assets. Is there a certain person you'd say they need to do this right away? Or what would you just generally say if someone's considering doing a trust?
So there's different reasons for doing a trust. There's the folks that want to have a trust because they don't think the next generation are sophisticated or responsible enough to handle the assets, and they need someone to help protect them. You have some folks that create a trust because it may have some tax advantages for their spouse, for their kids, and so they have tax planning involved in it. You have some people that want to trust because there's creditor protection. They're concerned about claims by third parties, and they're trying to put these assets into a trust to protect them for themselves and for their kids and whatnot. And so each of those types of reasons can have different planning and different things you need to have concerns about. For example, if you're just concerned about your kids not being sophisticated enough, a revocable trust is a perfect venue for you. You can change it at any point. You can change who the beneficiaries are. You can change the distribution standards. You can change who the trustees are. You as a settlor, the person creating the trust, have the right to change it in any and all ways. Problem with that is that may not give you the tax advantages you want, depending upon the language of the trust. It's not going to give you the creditor protection you want if you have that kind of trust. So you just need to have, once again, a sophisticated planner who can tell you kind of what is the reason you want the trust for and how we're going to document that to make sure that you get the benefits from it.
And how should someone interview? I mean, I talk to a significant amount of estate attorneys, especially in planning and sometimes in the administration side. How should someone interview an attorney or a planner to help them make these decisions? What questions should they be asking?
That's a great question. And I would say, some of the things I would ask them about is, first I would just glean their personality and see, are they someone who listen, or are they someone who's trying to tell you? And there are some planners, and I won't say who they are, that try to fit square pegs into round holes all the time. For whatever reason, they just really have some platform, some idea of planning that they want to push on their clients, and they're going to. It's not the best plan for that client. So I would be very cautious, and that's why I think you should you should interview multiple. Make sure you get someone who, first of all, I'm on the board of the Texas Board of Legal Specialization. There is a board certification for estate planning lawyers. And these are folks who have proven to have experience. They have to have a certain amount of experience to be able to even sit for board certification. Then they have to pass a very rigorous examination that lasts 6 hours. And it's involves tax, involves planning. And then if they pass that, then they become board certified. So if you have a board certified estate planning lawyer, that's got to give you a lot of comfort that they're at least sophisticated enough to be able to handle your estate. And I say that because there's a lot of estate planning lawyers who maybe have never done a 706. If you don't know the tax implications of an estate plan, you shouldn't be doing an estate plan. And so that's, I know enough about tax law to say, hey, I need to get my partner involved in it, right? I do litigation. I've never drafted a will or a trust for anybody that I get paid for. I've done it for myself, and I've gotten some more qualified to do it since. But that's number one, find someone who's competent. And two, make sure the personality fits with your personality. They're not trying to sell you a product. They're trying to listen to you and try to accomplish the best things for you and your family. Three, I don't like lawyers who try to insert themselves. Let me name myself as the executor. Let me name myself as the trustee. I would avoid those lawyers if they're trying to suggest that, because they're trying to set themselves up in a position for future fees. Now, a lot of times, the person who's signing, the settlor or the testator, the person who's signing the document, wants the lawyer to come into those positions. That's a different circumstance. But if you have a lawyer offering to do that, I would probably think twice about it. Third, I would say, talk to them about specific examples of how they would solve, future conflicts and problems. How is this document going to help protect my family from future conflict? What suggestions do you have for me right now to do to help avoid that? And then listen and see if they've got good solutions. And I would go to the lawyer that you feel like has the best competence, has the best personality, isn't really trying to set themselves up for future work, and who has good solutions for my particular family and the dynamics of my family.
Going back for a second, just because you touched on something that I'm curious about, and you may not know all the implications because this may not be your specialty, but what are the tax benefits of a trust?
I am not probably the person to ask that. The primary one is to take the assets out of your estate. So at the end of your life, you have estate taxes, right? And those can be up to 40%, maybe even higher estate taxes on your estate. And so you want to try to decrease your estate. You have, and so one point of doing a trust is getting those assets out of your estate into a trust so that you aren't taxed on them, or that the tax is done later maybe at the death of your spouse. So you're delaying the payment of tax. And so that would be one reason. Another reason is as potential income tax benefits for the party. Thirdly, you can have gift tax savings depending upon how you structure it and how you do it. And so there are multiple different types of tax savings you can do. Once again, I'm not the person to talk to about that. I would refer it to one of my partners. I've got some fantastic partners that I work with regularly who do really high level estate planning, and I always go to them when I have questions.
Well, and that actually brings me to my next point, which is, okay, so you're at Winstead. What are the various types of law that you would say that people should refer business to you or to your partners there?
Well, Winstead's a full service law firm. So I've got partners that do probably anything that your average wealthy, high net worth person would have needs for. We have tax lawyers, we have real estate lawyers, an oil and gas partner that I work a lot with, because if you have a trust dispute in Texas, you probably got an oil and gas issue. So I've got a board certified lawyer who I work with on probably, a third of my cases, and she's fantastic. I've got a partner that ran a family office for 7-8 years. He knows how the regulatory implications of it. He sets up family offices. And so I do a lot of work with family offices, because usually a family office has a trust and has closely held business interests. And so they need an advisor, someone like me, to help them, make decisions, document how we're going to get releases, and make sure everybody's copacetic. And am I meeting my fiduciary duties? I have a lot of family office clients and corporate trustees who may need help with regulatory issues or whatnot. And once again, people have real estate issues. You got, real estate transactional partners who can help. That's the nice thing. What you do see in my area oftentimes are people at boutiques, whether it be fiduciary litigator. They have a couple of partners who do the planning. They're in a firm that has maybe 5 lawyers, 10 lawyers, 15 lawyers. The nice thing about being in a more full service law firm is I'm able to bring in expertise on my team in-house, whether it be a real estate dispute, oil and gas dispute, closely held business dispute. I got a partner that can draft buy-sell agreements. I got a partner that can help with other corporate issues. So that's kind of your typical client that would come to me, and I refer them to my partners when that's the right thing to do. And luckily I get to work with some fantastic folks that I have a lot of trust in.
So you have a blog, fiduciarylitigator.com. And where else can people find you, or how else can people reach out if they have opportunities to work with you?
So I'm on LinkedIn, and I have my blog. I post on JD Supra, post the National Law Review, and people can go to the Winstead website, www.winstead.com. You can click on the persons or people, and you can click on me and send me an email. So there's any number of ways that you can try to contact me, and and I'm usually pretty quick about getting back. Oftentimes I have a statewide practice, so I travel a good bit to sexy places all over the state, and there's lots of ways to get a hold of.
That's excellent. Well, I want to just leave you any final thoughts or final stories that you'd want to share around your entire profession or from your profession. Any final thoughts to share with the audience?
Like any profession, there are good folks and bad folks. And I'm very proud of the legal profession. I think as a general proposition, the lawyers are the stalwart that keep our democracy moving and going and being a democracy. I would say, though, you have to be careful when you hire lawyers. There are some lawyers, especially in my area, that try to create disputes and try to create hostility because it benefits them. And so find a lawyer who you have a lot of trust in, who thinks first, acts second. And so that would be my advice, is to make sure you get someone who is smart, understands the law, is looking out for your best interest, which may or may not be filing a lawsuit.
Totally. Love that. David, this has been great. You brought some great information. It's going to be excellent. That's it for today's episode of the Wealth Transfer Podcast. If you found value in this conversation, would you leave us a review? That would be just so honoring to us. We'd appreciate it. And if you know somebody who might need to listen to this because they're thinking about their next chapter, will you send them a link to this podcast or this video so that they can listen more as well? For more episodes and expert insights, be sure to follow and subscribe. That means the most to us. Follow and subscribe, please, please, please. And when you're ready to take action on your own real estate plan, or if you need help with wealth transfer planning, we know a number of experts in all the different spaces. We'd love to connect you with them. You can reach out to us via direct message or comment. You can email us, matt@templeton.realestate. No .com, just templeton.realestate. And I'd be happy to connect you with an advisor. Thanks so much.